A landmark ruling by the UK Supreme Court could trigger multiple legal challenges by men convicted of sexual offences in Scotland. It ruled that since 2017, Scotland's courts have taken an approach to evidence which risks depriving a defendant of their right to a fair trial. The Law Society of Scotland has welcomed the judgment, while Rape Crisis Scotland says it could represent a step backwards for victims. Our Home Affairs correspondent David Cowan reports.
The UK Supreme Court first heard this case last October. It's taken a year for its full judgment to arrive. Two men convicted of rape argued their trials were unfair because they weren't allowed to read certain evidence about their alleged victims. Today, the Supreme Court rejected their appeals but said Scotland's approach to so-called rape shield laws could breach the European Convention on Human Rights.
The Supreme Court unanimously dismisses the appellant's appeals, but it finds that the Scottish courts should modify their current approach to the admission of evidence in trials for sexual offences, as it is so restrictive that it is liable to infringe defendants' rights under Article 6 of the
Rape shield laws are designed to protect the complainer, the alleged victim, from facing unfair or intrusive questions about their sexual history. A campaign involving supporters of men convicted in the courts say the rules have stopped them from presenting a full defence. That campaign has been criticised over its conduct towards victims, but its basic argument is echoed by legal organisations who intervened in the case in London. They argued successfully that Scotland's courts had gone too far.
Juries were not being trusted to use their common sense. And the judgment today allows judges greater freedom to say to the jury, you are trusted now to look at these facts, but we'll give you guidance in how you can use them and how you must not abuse those facts.
It will give the trial judge the discretion to deal with the issues case by case.